Dean Obeidallah. He wants to be your Muslim friend.
Most Muslims, I know many, are great people.
Watch this.
People.
You're listening to the Dean Obeidallah Show, where comedy meets politics and all things in between.
And welcome back, Dean Obeidallah Show. We're live here Wednesday, September 28th. Right now, very happy to have on Glenn Kirschner, former 30-year federal prosecutor serving in the U.S. Army and JAG Corps. You see him all the time as a legal analyst on MSNBC and NBC, and host of Justice Matters with Glenn Kirschner on YouTube, which he's working in the office now on a video. So he's still in the office, and that's why I'm watching him live via Zoom here. Glenn, welcome back. It's good to see you.
Hey, great to be with you, Dean.
And thank God you're here, because last night we had Danny Zavala's defense, reasonable doubt, everyone's innocent, stop it. These are the Oath Keepers, put them in jail. So I was joking with him because he was saying, the Oath Keepers, it might be a viable defense. I'm like, I'm not going to argue with you because tomorrow's Glenn's on, and he's going to set the record straight. So the Oath Keepers, I went through it in painful detail for the audience last night in the first hour about so much of what they were doing 2 days after the election, to how in the indictment it has their reaction to Trump's tweet on December 19th. Oh, yes, sir, we're going to make it wild, sir. And how their whole thing was planning and training and spending money to prevent the peaceful transfer of power to keep their beloved Donald Trump in office and keep Biden out. So the trial with jury selection began yesterday. And Stuart Rhodes is the big defendant. He's the head of the Oath Keepers. So what is your take? What can you share a little bit about seditious conspiracy here, the charges, like in a nutshell for people? And then we'll talk about your take on their potential great defense that Danny loves so much.
So, Dean, let me do two things really quickly. Let me run through the charges in the indictment, and then let me talk about what kind of conduct it takes to commit the offense of seditious conspiracy. Real quickly, here are the charges. Seditious conspiracy is the lead charge. Then there's conspiracy to obstruct an official proceeding, the certification of Biden's win, obstruction of an official proceeding. Your listeners and viewers should know that you can commit a conspiracy, and that is a standalone independent crime. So if you and I conspire to rob a bank and we take one step in the direction of robbing the bank, but we never rob the bank, we have still committed the crime of conspiracy to rob a bank. So these guys are charged with seditious conspiracy, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, conspiracy to prevent an officer from discharging duties, destruction of government property, civil disorder, assaulting, resisting, or impeding officers, and tampering with documents or proceedings. Now, perhaps most importantly, when we hear the term seditious conspiracy, we usually shorthand it, right? We say, well, that's a conspiracy to violently overthrow the government. Yes, it is. But you can also violate the seditious conspiracy statute in a number of other ways. And I think we're going to hear about some of this during the course of the trial. I was in the courtroom for some of jury selection. I'll be back in there for opening statements, which will probably not take place until Monday because they're still working their way through jury selection. But the seditious conspiracy federal law is really short. And here is how it reads. If two or more persons conspire, that is, agree to commit a crime, they conspire to overthrow, put down, or to destroy by force the government of the United States. So that's the violent overthrow of the government part, or levy war against the United States, or oppose by force the authority of the United States. Here's the important part. Or by force to prevent, hinder, or delay the execution of any law of the United States. So if they went in there trying to prevent, hinder, or delay the certification of Joe Biden's win, guess what? That is a seditious conspiracy. And there's one more in the statute. It is or by force to seize, take, or possess any property of the United States against the authority of the United States. If you seize control of the Capitol, you take possession of it, even if only temporarily, that is also a seditious conspiracy. So actually, the prosecutors and the two prosecutors I am pleased to report are people that I know, that I worked with in homicide. One of them I tried her first murder trial with. These are fabulous public servants. Jeff Nestler and Catherine Rakosi, the people of the United States will be extremely well served by these two prosecutors.
So that brings us to what the New York Times reported as the defense is going to be. They're going to tell the jury through the defense attorneys, and Stuart Rhodes is going to testify, at least that's what we've been told, that when the armed teams of the Oath Keepers prepared to rush into Washington, D.C. from Virginia, and that everything they were doing that day is because they believe they were following legal orders from Donald Trump himself. They expect him to give the order and invoke the Insurrection Act. How good of a defense is this?
That is such a poor defense. You know, some defendants have a strong factual defense. Some defendants have a strong legal defense. The Oath Keepers have neither. Why? Because one, Donald Trump didn't invoke the Insurrection Act, so they couldn't have been following orders that weren't given. Two, even if he had, this ragtag bag of white, white nationalist groups and white supremacist groups wouldn't have been lawfully permitted to rush in with their guns in any event. But here's the thing, Dean, they actually were following orders. They were following orders to go to the Capitol, fight like hell or you won't have a country anymore, stop the certification of Joe Biden's win. They were following illegal orders, which, as we all know, is not a defense to crime.
What they were doing, there's no denying it. When you read the reporting about it, some elements of the indictment I went through, they believe with every fiber of their being that they were doing this for Donald Trump, that they believed the election was stolen because Donald Trump told them it was stolen, that they were being called there for January 6th because Donald Trump tweeted, be there on January 6th, it's going to be wild. And they said, Kelly Miggs, one of the defendants, in a Facebook chat, which is in the indictment, said, he's calling us to the Capitol on January 6th. He wants us to make it wild. Yes, sir. We're going to D.C. Yes, sir. And they're doing what he wants. They're not going there and doing this if Donald Trump doesn't lie about the election or call them there on January 6th. How, for the life of us, is Donald Trump not a defendant in this trial?
I don't know, Dean, and that is a deep injustice at play in America right now, right? The boots of the insurrection. The people who Donald Trump lied to, convinced their vote had been stolen, and then ordered them to attack the Capitol. And we now know, courtesy of the J6 public hearings, that he knew they were armed, and he wanted to facilitate them being armed when they marched on the Capitol. So he told them to take down the metal detectors. They are being held accountable. They're being tried, convicted, and imprisoned. And Donald Trump is playing golf and holding hate rallies. I mean, if that is not a deep injustice at play in America right now, I don't know what is. And we haven't seen 1 minute of accountability visit the command structure of the insurrection, the suits of the insurrection, only the boots of the insurrection. And that is not right.
Do you expect, if Stuart Rhodes testifies, as they say, do you expect them to talk about, even if it's not Rhodes, the other lawyers, their lawyers, to make this a Donald Trump production? Saying, look, this was all because of Trump, that they believed it was fraud, that kind of defense?
I hope, first of all, I hope Stuart, or Elmer, let's call him by his actual name, which reportedly he hates, Elmer Rhodes, boy, do I hope he testifies. You know, the most fun I ever had as a prosecutor was cross-examining defendants. I had a RICO defendant testify, and I got to cross-examine him for a full 8 hours of a trial day. And it was just, it was so much fun. I don't believe Elmer Rhodes will testify, but if he does, I can tell you the two prosecutors will decimate him on cross-examination. But here's the thing. Let him say we were following Trump's orders. I embrace that because it's not a legal defense. Maybe what they're doing is trying to, go for the low-hanging fruit in the jury box. Maybe they think they can confuse one juror with that kind of nonsense. But remember, the prosecutors are undefeated in all of the trials that have been conducted thus far against people who attacked the Capitol. And others have said in those trials, I was just doing what my president told me, and they were still convicted. So I'm not liking Stuart Rhodes' odds of winning an acquittal.
I'm talking with Glenn Kirschner. So, Glenn, you mentioned you were at jury selection today, and I was reading that the judge there, Judge Mehta, he actually dismissed a juror because there were some Facebook or social media tweets were anti-MAGA, and he said, the judge, I would rather people who retweeted what the juror has not sit in judgment in this case, and that whatever the outcome of this case is, it has to stand up to public scrutiny. And I found that really interesting. And it almost seems like something a judge would say if Donald Trump is one day put on trial. And what can you share about the judge here? And they actually found what the juror, the prospective juror, wasn't a juror that was sworn in, a prospective juror had tweeted on social media. Is that something you think we would see in a Trump trial?
You know, I think it's a challenge to pick a fair and impartial jury because, you know, feelings run so deep for some when it comes to not only politics generally, but what happened on January 6th. Let me first say that Judge Amit Mehta is a former public defender in the courts of Washington, D.C., and he was a very good lawyer, and he is a very good judge, and I think he's doing his best to try to pick a fair and impartial jury. And what people need to remember is when we're trying to impanel fair and impartial juries, we need to remain focused on being fair to the defendant. But guess what? The people, the prosecution also has a right to a fair trial and to fair jurors. So, you know, people often think that, well, we're looking for jurors who don't know anything about the facts, who don't know anything about the insurrection. Frankly, I question the suitability of somebody who has no idea that the Capitol was attacked on January 6th. I don't know under which rock they might be living. But the key really is when you ask jurors, okay, look, you may have political, you know, preferences and affiliations and priorities. You may be Republican, you may be Democrat, you may love Trump, you may hate Trump. The question is, and the jurors are asked these questions under oath, under the penalties of perjury or contempt of court. Can you set aside whatever strong feelings you have? Can you set aside whatever information you may have as a result of reading accounts or watching TV or, you know, being on social media? Can you set that aside and swear under oath that you can decide the case fairly and impartially based only on the evidence you see introduced during the course of the trial? And then, Dean, we have to gauge the sincerity and the candor of every single juror when they're going through that voir dire, that jury selection process. And it is a bit of a crapshoot, but, you know, you bring to bear all your life experiences on selecting a jury, and, you know, we try to get a fair and impartial jury.
Look, you were a prosecutor for 30 years. Just so people understand, because people might think, well, jurors, who knows what they're really saying? Are they being honest in the voir dire selection, that kind of stuff? Do you find people in the jury box take this seriously and they have a sense of solemnness and they understand their responsibility in our big picture of our society?
Almost always, Dean. I mean, as flawed as our jury system is, I was impressed every time, you know, I stepped in front of a jury, and I tried a lot of cases in 30 years. The jurors who really want to try to find a way out of jury selection because they don't take it seriously or they don't care about their civic duty, you know what they do? During individual questioning of the juror, they'll say something like, well, I can't be fair because I hate anybody who's been charged with a crime. And you know what? Frankly, we know that person is probably full of nonsense and just trying to get out of jury service. But you know what? I was always happy that those kind of people self-selected out. And judges sometimes wouldn't let them off the hook so easy. But the people who, you know, are not going to be fair and impartial, generally we can mine them for that information during that individual questioning. And we're going to get a sense that, you know what, this just would not be a good person to sit on a jury. So, but once those 12 people are in the box, 12 plus however many alternates the judge impanels, my experience was always that they took their job very seriously and they tried to reach a just result.
I was in New York. You get called for jury duty all different times, and I got called shortly after I stopped practicing law. I was working at Saturday Night Live at the time, and I got called, and I remember I'm in the box, and it's a civil case, and they're asking prospective jurors, and they said to me, it was like an auto accident case or something, and they go, can you be fair? And I go, as fair as a defense attorney could be. And they go, thank you. You can leave now. Because they said, what kind of law did you do? I said, I represent insurance companies against people who got hurt. Like the exact same case. I was just being honest. I go, I'm like, as fair as someone who practiced defense law for insurance companies could be. And that was the end of me. I had to think. And I was not being playful. I was being sincere. Like, if I went in there, there's only one way I could view it. I would be questioning everything. I'd be like, this MRI is bullshit, folks. Come on. Here's the report. Like, that kind of stuff. There's nothing you can do. It was right in my bailiwick. Like, if it was something antitrust, I'd been like, sure, I could be fair. I've never done an antitrust case in my life. I have I don't bring anything to it that another person doesn't. We're all in this together. So I'm chatting with Glenn Kirschner. So, Glenn, let's talk about Judge Deary here in New York, a judge that I knew his name before this whole thing. He's a well-known judge. He is the special master. It seems that Raymond Deary, the judge, is pressing Trump team in ways they don't want to be pressed because they're making Trump's lies. Judge Deary's making his lawyers answer about Trump's lies. And one specific thing is not just the declassified or classified, but the thing about Trump saying there was evidence planted. And the judge wants to know from the other side, from Trump's lawyers, are you going to say the evidence is planted? So what can you share about this?
Judge Deary is doing the job he has been tasked with. He's trying to gather information. For example, did Donald Trump declassify any of these documents that I am about to review? That is because he's trying to approach his job in an informed way, because it might impact. Now, the whole claim that there is some executive privilege or attorney-client privilege that attaches to classified documents is absolute nonsense. But if Judge Deary is going to do an informed, review of these documents, he wanted to know, well, did you declassify any? So I know what I'm looking at and how I should assess them. And I'll tell you, Dean, the most candid thing I think I've ever heard from a Donald Trump defense attorney was in response to that request from Judge Deary. His defense team wrote Deary a letter and said, Judge, we're not going to answer that question, which is unusual. You usually don't tell a federal court judge you're not answering his question. So they said, we're not answering that question because it could hurt our ability to defend Donald Trump when and if he is criminally indicted. Boy, there's a tell right there. You can see what they're preparing for. And now there's a second question, as you mentioned, which is, did the FBI plant anything? Because Donald Trump is running his mouth claiming that some of these documents may have been planted. I predict, Dean, he's going to get the same kind of answer. Judge, we can't answer that. One, we haven't had an opportunity to look at them all and review them, and they'll do the little mealy mouth dance around the question. But, the same holds true for this question. If we answer it, we are potentially cutting off an avenue of defense when Donald Trump is indicted. So they're going to find ways to get out of answering that question as well, I suspect. And
so it's not something the judge would press them on? He'd have to accept that?
Well, I mean, this is, Dean, really akin to Donald Trump's lawyers pleading the fifth for him, saying, we're not going to answer these questions that would potentially incriminate or harm Donald Trump's legal position. That's what this is an exercise in right now.
It is remarkable to see this game play. Do you think, look, we've talked so many times about charging Donald Trump with crimes. It's exhausting. We've talked about it. I know you're at your wit's end as well. Do you think with these documents, is this an easier case for DOJ to make because the January 6th case seems a little overwhelming to them, to be blunt, or they don't want to? Is this one that they could look away and go, well, you know what, it's too close, we're just not going to charge him?
How can you look away? How can you look away when Donald Trump stole classified documents? We know he compromised our national security in the process, and then he kept them in his office, including in his desk drawers, when the government asked for them back, demanded them back, subpoenaed them back. And then his team wrote a letter certifying that they had all been given back. Every other person in the future who is charged with mishandling classified material will raise a selective prosecution defense if Donald Trump goes uncharged. Selective prosecution is a difficult thing to prove. It's not often successful when raised, but it might be more successful if the Department of Justice fails to prosecute Donald Trump for what is about as close to an open and shut case, classified documents in your desk drawer, as you're going to get in the arena of mishandling classified material. So if they give Donald Trump a pass for this, I don't have high hopes for our ability to guard our nation's secrets in the future.
How does it look, you've worked in the criminal justice system for over 30 years as a prosecutor. You talk about it for a living. How does it impact your confidence in our system that it's been over 630 days since January 6th attack, that we know from January 6th he attempted a coup, we know about these classified documents, and he's not charged with anything?
My confidence is shaken. It's shaken. And my sense of justice, if we don't have equal justice, then we don't have any justice. And I'm not going to go back to the boots of the insurrection going to prison and the suits of the insurrection playing golf and attending dinner parties. But my confidence is shaken because we've seen crimes committed by Donald Trump. We know by Mark Meadows. Mark Meadows was referred for prosecution for contempt of Congress. Congress was the victim. A co-equal branch of government was the victim. By extension, we the people were the victims because we're trying to get evidence necessary to hold criminal politicians accountable. And the Department of Justice has refused to indict Mark Meadows for his crimes. That is inexcusable. John Eastman, the architect of this, whole fraudulent elector scheme trying to criminally overturn the results of a presidential election, has not been charged with a crime. Jeffrey Clark, a high Department of Justice official who, yes, had his, cell phone seized after a judge concluded there was probable cause to believe there was evidence of crime in Jeffrey Clark's phone, has not been indicted. A federal judge in California found by a preponderance of the evidence that John Eastman and Donald Trump were involved in a conspiracy to defraud the United States and a conspiracy to obstruct Joe Biden's election win. And they haven't been indicted. There's no excuse for this. There's no acceptable explanation for the delay. Dean, every day I wake up expecting to see, finally, we have a big old conspiracy indictment to commit offenses against the United States because we've seen those crimes committed. And every day I am disappointed. My confidence is shaken.
My friend, Glenn, I want to thank you. I know it's been a long day. You were in a courthouse today watching jury's election. I so appreciate your time and your insight. Check out Glenn's YouTube channel, Glenn Kirschner 2 on YouTube. Is that the correct thing? I always ask, is that your Twitter? All right, brother. Thanks so much for being on. I appreciate it.
All right, Dino.